All right. Hello and welcome to MG316, another satellite tutorial. And in today's satellite tutorial, we are going to look at employment relations in Australia. This is our second last country that we are going to cover employment relations in Australia. After this, we have got ER in New Zealand, and that is our last country to cover in this course. However, please note that you are to add one more country to this list, which is your own home country. So please add that to this list. So in total, we would have studied UK, USA, Japan, Germany, Sweden, Australia, New Zealand. So that's seven countries plus one Pacific Island country, which makes it the eighth country. Yeah? All right, so let's look at our today's outline, lecture outline, employment relations in Australia. We will look at some key themes. We will look at the context, shifts in patterns of employment, legal, economic, political background, legislative changes from work choices to Fair Work Act, unions, employers, government, some processes such as wage determination, dispute resolution. We look at some current issues such as workplace productivity, unemployment, working hours, gender equality, and we will finally conclude. So, some key themes in recent decades, the Australian employment relations system has undergone a number of changes. So, let's look at what are some of these changes. There has been significant legislative changes, significant structural changes, significant decline in union density and union power, significant increases in non-standard form of employment, those atypical employment, shift away from a centralized industrial relations system to a decentralized system focused on enterprise bargaining. So these are our key themes. Context. So Australia had a population of 23 million and a GDP of just over 1.5 trillion dollars US dollars. Of the 11.4 million people in the Australian labor force, 77% are employed in the service industry, and this is in line with what we have seen in other countries as well, isn't it? That the service sector is the largest sector now compared to all the other sectors. So 18% is there in the manufacturing industry and construction, and the remaining uh, 5% is in the agricultural sector. So Australia's economy remains highly dependent on its mining and agricultural industry, despite these industries employing a mere 5% of the total workforce. So majority of the workers are there in the service industry. Australia has generally experienced strong economic growth from the 1980s to 2007, with the exception of a sharp downturn in 1990 to 91. Shifts in patterns of employment. The structure of employment has changed radically in recent years. And how has it changed in recent years? There is a decline in full-time permanent employment. There is expansion of various forms of non-standard employment, such as casual work, temporary jobs, outsourcing, use of agencies, and other labor market intermediaries. Part-time jobs have been the fastest growing area of employment. So this is how the structure of employment has changed in Australia, and it is not that different from what we have seen in other countries as well, including USA, including Japan as well. Outsourcing has been taking place. Casual employment is on the rise. Lifetime employment in Japan is declining, and in Australia and in Sweden, in Germany, full-time employment is declining. Even in UK, and you will see in New Zealand as well, the full-time permanent employment is declining, and there is increase in casual, temporary outsourcing, use of agency workers. Part-time is increasing, more females joining the workforce. Political context: since 1901, Australia has been a federation, a system of government with a central federal government and six regional state governments, just like what we have seen in America. One federal government and 50 state governments. Likewise, in Australia, they have one federal government and six state governments. The federal government is limited under the Australian Constitution to only make laws in relation to industrial relations with respect to conciliation and arbitration for the prevention and settlement of industrial disputes extending beyond the limits of any one state. So that's a direct quote from the Constitution. All other industrial laws were initially the jurisdiction of the states. So the federal government does not have much power in industrial relations. It only had some conciliation and arbitration for the prevention of disputes. That's it. But now it has changed a lot. So, legal context: the Conciliation and Arbitration Act of 1904 established the conciliation and arbitration system, which operated until 1988. Quite a long time, isn't it? For 84 years, this act was in power. The system was technically limited to industrial disputes beyond the borders of a regional state. Yet, the practice of unions saving logs of claim on employers from different states, artificially creating an interstate dispute, meant that it became the main avenue for dispute settlement and award negotiation. Most disputes were settled by negotiation, not arbitration. Please note that. So, disputes were mostly settled through negotiation, through collective bargaining, not through arbitration. The Hawke Labour government passed the Industrial Relations Act of 1988. So this is when the Conciliation and Arbitration Act of 1904 was repealed. Significant changes were also introduced in the 1993 by the Keating Labour government in the form of Industrial Relations Reform Act 1993. Now, what did this act do? This allowed the federal non-union collective agreements to be certified for the first time, incorporated a limited right to protected industrial action during a designated bargaining period. So, for the first time, Non-union collective agreements were to be certified, right? So collective agreements that were negotiated not by the unions, basically, and prevention of disputes, prevention of strikes and lockouts during a designated bargaining period. This is similar to what we saw in Japan, whereby during the negotiation season, the Shunto, no, none of the parties can do a strike or a lockout. They have to come to an agreement or during that bargaining period. Let's look at the Work Choices legislation, Work Choices Act. In 1996, the Howard Liberal National Coalition introduced the Workplace Relations Act of 1996, which limited the power of AIRC, that's Australian Industrial Relations Commission, AIRC, and also made it possible to register individual contracts known as Australian Workplace Agreements, AWS. In 2005, so until 1996, before going to 2005, individual workers did not had uh, contracts. There was just collective contracts or collective agreement. After the collective bargaining process, you ended up with the collective agreement or the agreement, also sometimes called the award. So after 1996, this Workplace Relations Act made it possible that individual workers had individual contracts known as ours, Australian Workplace Agreements. So in 2005, the Howard Liberal government passed the highly controversial Work Choices Amendments to the Workplace Relations Act of 1996 that had previously been rejected by the Senate. And this included creation of a national system of industrial relations under the corporation's power of the Constitution, thus removing state control of industrial relations and allowing the federal government to set minimum terms and conditions without recourse to awards for 85% of the workforce. The ability for hours to undercut award collective agreement conditions, significant restrictions on union activities, reduced role of the AIRC, exempted businesses with fewer than 100 employees from unfair dismissal laws, introduced five minimum employment conditions. So as you can see that work choices would obviously be not favored by the unions, isn't it? Like significant restriction on union activities. Do you think unions would like it? Yes, obviously not. And this exemption for businesses with fewer than 100 employees from unfair dismissal laws. Again, employees would not like it if they were unfairly dismissed by such a organization. So work choices was not that popular. Work choices was deeply unpopular in Australia, and combined with the strong union media campaign called Your Rights at Work contributed to the Liberal National Coalition losing the 2007 election. So due to these changes that was brought in by work choices, the government lost in the 2007 election. Moving on, so transition to Fair Work. Currently, Australia has Fair Work Act. Please note that work choices is not there, not any other legislation. There is a major legislation called Fair Work Act. So after Labour's election victory in 2007, the new Rudd Labour government pledged to roll back work choices and implement a fair and balanced industrial relations policy. The new policy was less of a recasting of the industrial relations system and more of a retreat from the excesses of work choices. So basically, this new policy actually tried to roll back whatever damages was done by work choices. So this is partly explained by the fact that the coalition and the independents still control the Senate, upper house of the parliament, and would have been unlikely to pass radical reforms. Fair Work Act of 2009 still there. So what are some of the features of Fair Work Act? Fair Work Australia being established as the new employment regulator along with the Office of the Fair Work Ombudsman to promote and enforce compliance with the new laws. So a Fair Work Australia commission was set up by this Fair Work Act. Hours to be abolished. So these are individual contracts to be individual contracts to be abolished, but individual common law contracts remain. 10 new national employment standards, which means minimum employment conditions for all workers under the federal scheme. Things like what we have called minimum wages, that is one of the national employment standards, minimum wages. So every worker is entitled to that minimum wages. For example, in Fiji, the minimum wages is $2.68 per hour. And there are other national employment standards. For example, again in Fiji, the minimum number of annual leaves that an organization has to give you is 10 days, 10 working days. Same with the sick leave, 10 working days. No organization in Fiji can give an employee less than 10 working days for or 10 days for annual leaves and 10 days for sick leaves. The organizations can give more, yes. Some organizations give 15, some even 20 annual leave days. It's up to the organization, but no organization can give less than 10 annual leaves. What about in your own home country? Find out what is some of the national employment standards, the minimum standards, employment conditions. New systems of modern awards to provide an additional safety net. Unfair dismissal extended to cover all employees except those working in a small business that had 15 employees or less or on probation. Employees earning more than approximately 100,000 to be on arrangements not based on an award. So these employees that earned around more than 100,000 per annum could negotiate their own contracts, employment contracts. Employers and unions now required to bargain in good faith but are not compelled to reach an agreement. So good faith bargaining, that tells us that collective bargaining is compulsory or voluntary. Yes, good faith bargaining, voluntary. However, the Fair Work Australia (FWA) can issue a workplace determination where a good faith bargaining order is ignored. Union officials are able to enter workplaces to talk to employees or talk with employees, provided that they hold a permit issued by the FWA and abide by conditions of the permit, including giving notice. Employees must be better off overall, that's a boot test, under an agreement then they would be under an award in order for the agreement to be registered. So these are some of the key features of Fair Work Act 2009. Very important legislation in Australia. So the Abbott government and employment relations. The Abbott coalition government was elected in September 2013. By the way, who's the current PM of Australia? Yes, Scott Morrison belongs to the Liberal Party of Australia party. Okay, that's the political party that Scott Morrison belongs to, Liberal Party of Australia. So the Abbott coalition government was elected in September 2013, promising minimal changes to employment relations despite some employees urging reforms such as allowing greater scope for individual employment contracts. Remember, employers, not employees, employers always want individual contracts. They don't like unions. Employers, the management guys, they don't like employees, and the unions. Sorry, the management does not like the unions, and they always want to negotiate individual contracts. They don't want to liaise with the unions. The government appears to be wary of providing labor and the union movement with any grounds on which to argue that it is reintroducing aspects of the unpopular work choices legislation and reigniting the successful Your Rights at Work campaign by the unions. The government introduced some minor changes through regulatory rather than legislative means, despite the Howard government's successful use of the corporation's power to enact radical legislative reforms to industrial relations. However, the government has established a royal commission into alleged trade union corruptions. So this is another issue present, and which could lead to trade union density decline, trade union corruption, and has initiated an inquiry by the Productivity Commission into the impact of Fair Work Act 2009 on various matters, including productivity performance. All right, so let's look at the three parties, starting with the unions. So, conciliation and arbitration encouraged the rapid growth of Australian unions, and to a lesser extent, employer associations during the early 1900s after the passing of the federal legislation in 1904. By 1921, approximately half of the Australian labour force was unionised. The union density has fluctuated during this time, dipping to 40% during the 1930s and then rising again to a peak of 65% in 1953. So it has fluctuated during this period, and it is similar to actually what we saw in UK, isn't it? That the union density had fluctuated. However, over the last 20-30 years, the trade union density in all the countries has been declining. So, union density in Australia has been declining steadily over the past 2 decades from 49% of the workforce in 1990 to 17% in 2013. So, at one point in time, you can imagine that the union density was 65%, and now it's just a mere 17%. The union density was 42% in the public sector compared with the 12% in the private sector in 2013. Again, similar with other countries as well, as I've told, I think in Germany, while we were discussing Germany or Sweden, that in all the countries, the trade union density is always higher in the public sector compared to the private sector. Look at the vast difference here in Australia. 42% in the public sector, that's the trade union density, 42%. And in the private, just a mere 12%. So, reasons for trade union density decline or reasons for union decline. The reasons for union decline are complex and varied. A key factor has been structural changes to the structure of the economy, including the contraction of manufacturing employment, which was traditionally strongly unionized. I did mention this, I think, while we were discussing UK, USA, that unions are strong in the manufacturing industry, isn't it? And when the country moves towards service industry, the unions are budding in the service industry and they are not really strong. And due to this structural change, there is union density decline. So rapid growth of the service sector and unions are weak in the service sector. Decline in full-time employment, increasing prevalence of non-standard forms of employment, atypical employment, more casual workers, temporary workers, agency workers. Other factors include growing anti-unionism amongst employees. As I've said, employers they don't like unions. In USA, we saw that there the management, the organization really practices anti-unionism, even to the extent that they shift their businesses to places where unions are weak. Removal of institutional arrangements which favored unionization under a centralized system of arbitration. Hostility towards unions by employers and conservative governments, such as work choices, restricted trade union movement, internal union politics and policies, for example, union amalgamations, did not achieve increased membership as anticipated. Australian Council of Trade Union ACTU, what is this? So the ACTU is the main confederation for manual and non-manual unions in Australia. ACTU is the umbrella body of trade unions. Simple as that. It was formed in 1927 and covers approximately 95% of all unionized workers. This high level of coverage is the result of historical measures with other powerful peak union bodies. During the 1990s, the ACTU, Australian Council of Trade Unions, encouraged and facilitated union measures, achieving a reduction from 360 federal unions into 20 super unions. So, unions merged and provide a greater voice. Successful Your Rights at Work campaign in response to work choices. In recent years, the ACTU has focused on strategies to reverse union decline. So they have been organizing campaigns in order to become less dependent on the government, on state, joining community slash and or social movements to support issues such as more secure employment. So that's about the unions. Let's look at employers and their associations. The Australian Employer Association. Conciliation and arbitration system led to development of Australian employer associations. First peak employer group was Confederation of Australian Industry and was established in 1977, almost 50 years after ACTU, the peak union body, the umbrella body of the workers. You see, in every country, the employee associations were the second ones to form. The first ones to form are always the trade unions. Disunity and fragmentation have been ongoing problems for Australian employer associations. In 1992, the CAI, Confederation of Australian Industry, the CAI merged with other peak employer bodies to form the Australian Chamber of Commerce and Industry, ACCI. Now, this is the current umbrella body for employer associations, ACCI, Australian Chamber of Commerce and Industry. A similar measure resulted in the formation of Australian Industry Group, AIG, and in 1983, the Business Council of Australia, BCA, was formed. And in BCA, the members are CEOs from Australia's largest corporations. So they have got three bodies. ACCI is the largest one, that's the main umbrella body, and then they have got the AIG and BCA. You will see something similar is also present in New Zealand when we discuss New Zealand next week. They also have got a business roundtable and things like that, whereby the CEOs of big businesses are members. Just like in Business Council of Australia, the CEOs from Australia's largest corporations are members. Most employer associations were vocally supportive of the work choices legislation. Obviously, why would not they be? Isn't it? With some bodies even funding pro work choices media advertisements. But AIG stood aside from these campaigns. Recent shift from industry advocacy to fee based services for members. So, no longer um, advice is free to the members, it's all now fee based. The role of the government, so that was about employers and their associations. Role of the state, the federal government's industrial relations powers were restricted by the Commonwealth Constitution until the High Court ruled that Howard coalition government could use the corporation's power to widen its jurisdiction. The state governments are now restricted to industrial powers in relation to its own employees. The Howard government advocated deregulation of the labor market but re regulated employment relations, reducing the power of the federal tribunal and expanding the role of the federal government. While the Rudd and Gillard Labor governments enacted legislative changes to strengthen the union collective bargaining rights and enabled employees in small enterprises to appeal to the tribunal against alleged unfair dismissal. This did not reverse all aspects of work choices. In contrast, the pre 1996 legislation, the Fair Work Commission has limited powers to intervene in disputes unless its services are sought by both parties. So that's about the government. We have seen a lot about the government in the legislations bit, isn't it? Okay, moving on to resolution of disputes or settlement of industrial disputes. How are disputes resolved in Australia? Initially, they did have the conciliation and arbitration system. So let's look at that. The historical system of conciliation and arbitration proceeded on the basis that conciliation would be exhausted before arbitration took place. Key aim of this system was to render strikes unnecessary. Under the conciliation and arbitration system, striking was illegal until 1930 when this provision of the act was removed. Yet, Australian workers only received a protected right to strike in 1993. So, even though from 1930s onwards striking was not illegal, the Australian workers only received a protected right to strike in 1993. During the 1980s and the 90s, average working days lost through disputes were 1,000 employees, halved due to changing macroeconomic conditions and the accord. So, still continuing on disputes, following 1993, workers could strike during a designated bargaining period, and the industrial regulatory body could intervene and determine if disputes were or if the parties were not acting in good faith. There was little chance of settlement, or if it was in the public interest. So only then the regulatory body would intervene if the parties were not acting in good faith, if there was little chance of settlement, and if it was of public interest. In 1996, the Howard government retained this provision in its reform, although in a more restrictive form. The strike rate continued to decline during the 1990s, and after 2000, it remained above the OECD average, but was significantly lower than the levels of 1980s. After 2000, there was an increase in employer-initiated industrial action in attempts to introduce non-union collective agreements in traditionally unionized industries. The 2005 work choices reforms further eroded the role of industrial regulator, the Australian Industrial Relations Commission, that is the AIRC, removing its compulsory arbitral power. So no longer AIRC could arbitrate. And then under the Fair Work Act of 2009, the regulator Fair Work Australia can only intervene where there is a breakdown between the parties in negotiation, or where the negotiations are causing significant economic harm to the parties. Determination of wages. The relevant federal tribunal has set a minimum wage in some form since 1907. From 1986 to 96, the dominant mechanism for settling the wages was through a social impact called Prices and Incomes Accord, also known as D Accord. Under the accord, the government and ACTU, that is the umbrella body for the trade unions, would present a joint submission to the national wage case. In most cases, the AIRC would accept the recommendation and introduce wage principles to give them effect. The accord was a trade off. What was the trade off? The unions would promise not to make extra claims in wage bargaining in return for increases in the social wage and a range of industry policies. The election of the Howard Liberal government ended the accord and its role in shaping wages policy. The AIRC continued to set a minimum wage. Under the work choices, the responsibility for settling or setting a federal minimum wage shifted from the AIRC to the newly established Australian Fair Pay Commission. So no longer AIRC set the minimum wages after the work choices in 2005 work choices, and this was transferred to Australian Fair Pay Commission. Following the Fair Work Act, minimum wages are set by a minimum wages panel under the Fair Work Australia. So after the Fair Work Act 2009 came into power, minimum wages are now set by minimum wages panel, which is overlooked by or looked after by the Fair Work Australia. Finally, let's look at some current issues, trends, and changes. Workplace productivity. Advocates of labor market decentralization argued that enterprise bargaining would stimulate increased productivity. Although there was an upsurge in both labor and multi-factor productivity after the introduction of enterprise bargaining agreements, there were also other factors involved, such as microeconomic reforms and greater utilization of technology during this period. Lower rates of national productivity in recent times are also due to a range of factors, including decline in investment in the mining sector. Remember, mining sector, agricultural sector only has got 5% of the total workforce, isn't it? Studies have indicated that productivity growth at industry level has been higher since the introduction of Fair Work Act than under work choices. But changes to employment relations policy appear to have little tangible impact on national productivity outcomes. Unemployment and working hours. After experiencing full employment and labor shortages for almost a decade, the unemployment rate rose from 4.3% in mid 2008 to 5.3% in mid 2009. Substantial government funding was credited with preventing the unemployment rate from rising beyond this point. Underemployment has been a growing problem. Working hours are also increasing. One in five workers is employed for more than 50 hours per week. The norm is somewhere around 40 to 45 hours per week. Even the norm is now decreasing to 37.5 hours per week. So, one in five workers is employed for more than 50 hours per week. Under the Fair Work Act 2009, workers can request flexible working arrangements, but employers they do not have any obligations other than having to respond to this request. Precarious employment. While unemployment appears to have been lower in Australia than most other OECD countries in recent years, there has been a large increase in underemployment and non-standard work. In 2010, 23% of the Australian workforce were employed on a casual basis, 13% on permanent part-time arrangement, and 4% on fixed-term contracts. Approximately 53% of female workers were in casual contract or permanent part-time jobs compared with the 28% of the male workers. Younger workers were overrepresented in this country compared with older workers. Non-standard employment is concentrated in sectors where unionization is weakest. That would be service industry, isn't it? The ACTU commissioned an independent inquiry into insecure work in Australia in 2012 to publicize this issue and seek government reforms, but to no avail. Both Labour and coalition governments have used temporary work visas to address persistent labour shortages in particular jobs and industries. Example, the agriculture and service sectors, but this continues to be a contentious issue in terms of alleged exploitation by employees. Gender equality at work. Women comprise 48% of the paid workforce in Australia, lower than Canada, New Zealand, and some other northern European countries. Women's wages are generally lower than male wages, and their employment is concentrated in low paid areas of work. The gender pay gap has widened from 16% in 2007 to 17.5% in 2013, although this varies between states and industry sectors. In the past, major advances in pay equality were achieved through test cases in the AIRC, but this stalled after work choices. The Fair Work Act of 2009 allowed Fair Work Australia to make orders requiring equal remuneration for work of equal or comparable value, replacing the more limited equal pay for equal value. Also removed need to prove discrimination. The Abbott government scrapped initiatives by the Labour government to improve pay equality for women in low paid sectors, example childcare and aged care. It also abandoned its proposed paid parental leave scheme. Finally, employee participation, employee involvement and participation in decision making. There was some evidence during the 1990s that the numbers of joint consultative committees were increasing. There is no legislation that mandates works councils, so employee involvement and participation in Australia is voluntary, it's not compulsory. Yeah? The merits of statutory works councils continue to be debated in Australia, including whether it would address the current representation gap or increase managerial prerogatives in the absence of a broader social partnership framework. There is growing concern about the lack of employee consultation, generally in the context of declining unionism. So these are some of the current issues, trends. Finally, to conclude, significant changes in the recent decades include significant structural changes, legislative changes, shift away from a centralized system of the past towards enterprise bargaining, significant decline in union density and power. The work choices legislation radically reformed the Australian industrial relations system with continuing consequences despite a change of government. The Fair Work Act redressed some of these excesses of work choices but may be reversed by the current government. There are ongoing questions about the role of collective bargaining, unions, and other forms of employee representation. So, this concludes employment relations in Australia. All right, if you have any questions, any queries, feel free to email me. And see you next week when we discuss employment relations in New Zealand. Please read employment relations in New Zealand. Thank you.